Next case on the docket is JOANNE Berry versus Walt Disney World Hospitality.
May it please the Court, I'm Eben Self on behalf of Ms. JOANNE Berry, the petitioner in this case. This is an appeal that stems from a motion for final summary judgment that was granted in the trial court. In that decision, the trial court ruled that Walt Disney World had no duty with regard to the plaintiff, and that they breached no duty, and that they assumed no duty, and that they had no duty to warn her of any conditions on this particular. This is the Mad Hatter's Teacup Ride at Walt Disney World's Magic Kingdom. I'd like to reserve 5 minutes for my rebuttal, if I may. This all occurred on August 18th of 2006. Miss Berry was with her family at the Magic Kingdom. Her 14-year-old son is a spastic quadriplegic who has cerebral palsy. They wished to ride the Mad Hatter's Teacup Ride. They went according to the...
Mr. Self,
yes.
Tell me, what was your theory of liability here was what?
The theory of liability was we pled counts of ordinary negligence against Walt Disney World. In addition to that, we pled a count of negligent mode of operation.
All right, let's talk about, let's kind of break it down because it seems like we have different analyses here. On your ordinary negligence, what was the duty that you contend that Disney World breached?
Well, they have a duty as a business invitee on the premises to Ms. Berry and her family. They have a duty of reasonable care to her for her safety. And there's a line of cases throughout Florida, which we've cited within our brief, that talks about amusement parks and racetracks and places of amusement, how those operators of those businesses have a heightened duty of responsibility to their patrons because they have people are there seeking amusement and watching the activities. They have a duty, an ongoing duty, to maintain the premises and to care for the premises in a reasonable manner.
So what was it specifically as it relates to your ordinary negligence counts? I mean, as I understand it, your contention was not, there wasn't anything slippery on the step or the step wasn't broken, anything like that. I mean, your contention, I think, was that was it an inherent design problem, that it's just a negligent design? I'm having a hard time with your ordinary negligence claim. We'll talk about mode in just a minute, but I'm having a problem with the ordinary negligence.
The ordinary negligence claim, I think, is sort of part and parcel of the mode of operation claim, but I think that the ordinary negligence is this responsibility that you bring in patrons and you bring them onto this ride.
I mean, I think we all accept that they have a duty to maintain everything in a reasonably safe nature. What did you contend that they did specifically? What evidence was there of something that they did wrong as it relates to the ordinary negligence claim? The failure to maintain their premises in a safe condition.
It's not necessarily that maintain, it's how it was designed. This particular Teacups ride is a turntable or a carousel type.
Sadly, I have actually been on it with my kids.
It's a ride I refuse to ride on only because I get dizzy when I spin. But it is a carousel, and it has 18 teacups. There are 3 spinning carousels within that.
What evidence in the record at the time that the trial judge entered his summary judgment, what evidence in the record was there of some sort of negligent design or negligent operation? I mean, did you have a...
Well, Disney...
Other than the fact that she fell, and I understand what your contention is, but other than the fact that she fell, what evidence was there that somebody, that Disney World did something that wasn't what they should have done?
They had a policy. I think the design, well, let's go back to the design for a second. The teacups themselves are designed to resemble teacups. And they have a very narrow door, and they have a very small saucer.
Did you have any kind of expert testimony or testimony even from her that there was something inherently flawed? I mean, as I understand it, she had just gotten on the thing
she said
90 seconds earlier, 2 minutes earlier. and had ridden it before.
She had said she had forgotten that there was a saucer. If you look at the photographs which are attached to the made exhibits to the defendant's motion for summary judgment, the teacups themselves are sitting on saucers. The saucers are themselves made out of polyurethane lip, and they have a separate lip. And the height of that, after you've been on the spinning ride, she said she didn't recall there being the saucer, and as she came out, that's what she ended up tripping on as she fell.
What about, as to your mode of operation?
Well, before you move on to that, let me ask a follow-up question. That under your theory then, on ordinary negligence, it's irrelevant whether she had her son with her. If she had been there all by herself on the teacup, same thing, stepped out, forgot to step, fell, your position would be she'd have a cause of action. Is that right?
I really believe so, because I think there is that heightened duty of responsibility to patrons at an amusement park when you're asking them, putting them on rides with music and spinning, and you ask them to step through a narrow doorway over the ledge of a saucer. I think just because the fact that they had just gone on there moments earlier is an issue of comparative negligence, and a jury is free to determine that the rider is more negligent or completely negligent or partially negligent because they forgot that existed. But in that particular inherent design itself, it's dangerous to think that you're going to be sticking 1 to 4 riders into that teacup. You're going to play music, you're going to spin them around, then you're going to ask them to get off, and remember that when they step back through that narrow doorway that they have to step over a saucer edge. In this particular case, though, Disney had a policy with regard to the handicapped riders, and that policy was that the handicapped riders were to come to the exit door. They were not to wait in the regular line where the Disney line goes back and forth until you get to the holding pens, and then you open into the teacups. And the handicap policy stated that you were to stand by the exit of the carousel, that the ride operator, there's only one ride operator there's 18 teacups and 1 to 4 riders per teacup. So between 18 and 72 riders on the teacups themselves, in addition to the numbers of people who are waiting in line to ride this particular ride. There's one operator. He is to, after he opens the doors to allow the riders to come in, they fill up the teacups. He walks through the carousel, turns the carousel on, it operates, and then he goes back, organizes the holding pen again, the riders exit, he then opens the gate and goes that way.
Was the evidence that the operator checks to make sure each door is closed?
It is, I believe, part of their walkthrough from their policies and procedures from the holding pen to where the button to start the carousel itself is actually opposite from the loading area. So he has to actually walk through the turntable, and as he's walking through, he's supposed to make sure, or she's supposed to make sure, that the doors are closed and that the ride is, that everyone is in a teacup.
So your client got up and tried to leave before the operator had started or finished this round of checking to make sure the doors were closed?
No, that's not exactly how the facts occurred, but let me back up.
If I remember the facts, according to your client, is she tried to get the operator's attention.
Right.
The operator had not started going through yet.
The operator had opened the pen, which then releases the general admission flow of people to fill up the teacups.
Right, but the ride was not going to be started until the operator went through and made sure all the doors were closed.
Correct, but Disney's policies and procedure was only half of a policy with regard to handicap riders. Their policy was to assist them onto the ride, but they had no policy in place with regard to helping them off of the ride. So I don't believe there was any testimony, and there wouldn't be any testimony, that the employee for Disney was going to assist in any way.
But your client didn't wait for any assistance?
Well, she waited until, again, when the stop button is pushed, the operator then has to actually walk back, open the general holding facility, which then releases the line. So all of that time had taken place. The operator had gone, pushed the stop button, the riders had exited, he walks back, opens the gate to allow people on. So all of that had taken place. My client had waited a significant period of time before making the decision to disembark the ride.
But your client knew that the operator was going to come through. Your client could have waited for the assistance that she thought she needed.
My client thought there was going to be assistance, but Disney's policy is that they provide no assistance, and their testimony in this case was that they provide no assistance to handicapped riders in getting off of the ride.
Well, the problem I had, you're saying that your client was not aware of Disney's procedure, and your client wanted assistance, and your client, and it was undisputed that the operator would go through before it started the ride back up to make sure the doors were closed.
Right.
So it seems to me that if your client had wanted assistance, and your client knew assistance was coming, your client simply chose to get up before the operator started walking through the...
She had been trying to get that operator's attention. She was trying to get assistance. The wheelchair from where their particular teacup had stopped was on the opposite side of where her son's
But is your
wheelchair was.
negligent mode of operation claim that they didn't provide assistance at all, or that they didn't provide assistance at an earlier time?
They didn't provide assistance at all, and they didn't have a policy in place to provide it.
Well, we don't know that because your client
Well, my
got
client-
up before the person started their walkthrough.
Well, I know that from the testimony, the Disney employee testimony that was in the case. The Disney employee testimony was that they did not have a policy to assist handicap riders off of the ride. They only had a policy to assist them onto the ride. There was no policy to bring the wheelchair over to the teacup. There was no policy to assist in any manner like that. Now, Disney's policy was that the transfer, in order to ride this ride as a handicap rider, you had to be able to transfer out of your wheelchair. And that was accomplished, again, in the particular case, in the loading aspect, waiting at the exit area. The family is then identified before anybody else loads onto that teacups. The teacup operator comes over, opens the exit door, allows my client and her family to load, brings the wheelchair right to the teacup. They load into the teacup. The wheelchair is then stored off of the turntable itself, and they're allowed to go through the ride.
Just so I understand their policy more clearly, though, when you say that they have a policy of assistance, help me understand what their policy really is. Is it simply that we let you get on, you come to the exit and we'll escort you over to your teacup, but it's your obligation to make certain that you're physically able to transfer up and down? Or does Disney undertake to physically assist a person, whether it's just a elderly person walking with a cane who might need a little help, boost up? I mean, do they physically put hands on them and boost them in there? Or do they just roll the wheelchair over, kind of stop traffic and say, okay, it's up to you?
It's more the latter than the former. Disney has a policy that does not allow employees to physically touch individuals with handicaps or elderly in terms of providing assistance. They can assist by wheeling the wheelchair close by. They can assist by moving the wheelchair off of the turntable in providing that type of assistance. But Disney's policy does not allow them to physically allow them to touch the handicap rider themselves.
Are you saying that that's negligent? That they're required to assist someone with a physical handicap?
I'm not saying that that's negligent. I'm saying what is negligent in this particular case is that they have half of policy, and that it lends the patron of the park to believe that there is a policy to help exit.
Okay, but the policy that you think they lead patrons to believe to help them off would once again not be to physically move them, right?
Again,
the policy would prohibit that.
Correct. It would be to give guidance in terms of bringing the wheelchair over. It would be better to be physically give assistance to say, watch out for this step. In a case of the Haunted Mansion, it might be to stop the walkway. There's a powered walkway in a lot of the Disney rides. They will physically stop that to allow an additional assistance to handicap or elderly riders.
So if they had a policy to help them off, which you say they have to not be negligent, it would be a policy that says, and they have to say, watch your step.
Well, I think they have to use reasonable measures in that particular.
And in this case, your reasonable step would include you'd have to, in every case, say, watch your step.
I think so.
And if they had the policy in effect and they brought the wheelchair over, but they didn't say, watch your step, if anybody falls, they're liable.
Well, I think that it's reasonable under those circumstances to have that. If they have the first end of the policy, it's reasonable to suggest that they should have the second half of the policy, because they're inviting people.
First half of the policy, watch your step going on?
Well, I think so. I think that's not an unreasonable thing to say when you're carrying someone or assisting somebody onto a teacup. I don't think that's unreasonable.
Was there evidence that they did that getting on? Is that why she didn't trip getting on, because they said watch your step? Or did she figure out for herself to step up and not?
I don't know what the testimony was regarding any kind of verbal warning as getting on, but I do know that in the record on 190, Walt Disney had no policy to help guests who had handicaps or special needs exit this particular ride.
But is your position they had a duty to tell every patron to watch your step?
Well, I don't know. I believe that in this particular case, the patrons with special needs, these are the circumstances in which these particular patrons and guests find themselves. Ordinary patrons, Disney provides lots of different warnings at various different times for parts of their rides, and so when they're in the holding cell area of this particular ride, the ride operator does give them specific instructions with regard to how to load that particular ride. Other rides, like the Aladdin ride, there are specific numbers that correspond to flying carpets, and so they're given instructions regarding that. This ride's a little different in that it's general admission, and that people can sort of run through that. So those people are given certain instructions. There are no similar instructions given to handicap riders who are waiting at the exit in this particular situation. We think that the Etheridge case that this court decided in December of 2008 is particularly applicable. The duty to exercise reasonable care may extend to taking actions, reduce, minimize, or eliminate foreseeable risks before they manifest themselves as particular dangerous conditions on the premises. We think that the circumstances of this case fit with the Etheridge case, and that summary judgment should be reversed. I'm going to save the remainder of my time if there are no more questions at this time for rebuttal.
You got about 3.5 minutes.
Thank you.
May it please the court. My name is John Smith, and I'm with the actually newly formed law firm of Hewitt & Walensky in Maitland, and I have the privilege today of representing Walt Disney World Hospitality and Recreation. A couple of quick matters. This truly is a case where there is no dispute as to the facts. A couple of facts that need to be mentioned, since they sort of came up here, were whether or not she was given a verbal warning to step up when she went onto the ride. While that's not in a procedure or anything of that nature, the plaintiff indicated that in fact she was told to step up, and that is on page, the record 310. One other thing, and that is as far as whether had she stayed seated or stayed in the vehicle, the ride vehicle, the teacup, after this ride, whether or not she would have been provided some type of assistance, and she's not going to be lifted, not going to be touched. And there are reasons for those policies not to touch or lift, because that could create a situation of causing more harm than good, particularly when you have a person that's disabled. But she was, there is in the record at page 309 testimony that, excuse me, it's not 309, 199, testimony that certainly our cast members would have been available to help that guest in any way they could if they were made aware that the guest needed assistance. And in this case, we are in agreement that she simply did not wait because this cast member and any cast member running the ride walks around the ride before starting it up for the next ride and makes sure that all the doors are shut and that all the passengers are seated and within the vehicle. So
Mr. Self made a comment that after she waited for an extended period of time, couldn't get the attention of the operator, she got off. Was there any evidence from Disney or from the other side as to, I assume Disney has normal standards that you ought to be able to unload, reload, and restart in a given period of time. So from the time the ride stopped until the time that she got off had to be less than the normal restart time. In other words, the gap between when it ends and when it starts again. Any idea what that time frame is?
There's no evidence in the record as to what it is, and I personally don't know. That didn't come up. That was not part of the evidence, and that was not something that was really even an issue before Judge Adams. One thing that hasn't been discussed, and I wanted to bring up, and I'm going to kind of skip ahead here as opposed to going the way I'd planned, and that is whether it's, there are two duties, obviously. One is to warn, and this is an open and obvious condition, so therefore there is no duty to warn of an open and obvious condition. There are numerous cases holding to that, two of which are City of Melbourne versus Dunn, 841 Southern 2nd 504, Miller versus Wallace 591 Southern 2nd 971. The second duty, and I think that's kind of what the court's been talking about, is the duty to reasonably maintain the premises. And in those situations, the first question that has to be asked is there a dangerous condition or a dangerous situation on the premises? Because all that we have here, and the only evidence that was in the file, and the only evidence that exists, and we don't disagree, is that this was a normal change of elevation. It was a step. Nothing unusual. There's no speed bump under it. There's no depression, gully under it. There's no drain under it. It is simply a change in elevation. And totally lacking in the file, in this case, is any evidence of there being anything wrong or defective or anything that is in any way dangerous or unsafe with respect to this property. And before you can get, or I would respectfully suggest that before you should get to the whole issue of mode of operation, which originally arose as a way of getting around the subjective notice requirement, before you get to mode of operation, there has to be some evidence that a dangerous or unsafe condition was created. And there is absolutely no evidence in our scenario, and the facts are plain, agreed to. Evan and myself have agreed from pretty much from the time of the summary judgment hearing to the present, despite some suggestions of otherwise in the briefs. There's no dispute as to the facts. And there is no fact showing that this change in elevation is in any way dangerous or unreasonably constructed, unsafe in any way. In every single case dealing with imposing liability upon a landowner requires some showing that there is a defect or a problem with the step. And there's a long line of cases dealing with changes in elevation, as this court knows. And they go from the Circle K case, which dealt with a difference in levels of concrete versus pavement, asphalt in a parking lot, to the situation in Rosenfeld versus Walt Disney World versus my case years ago of a curb inside the Magic Kingdom on Main Street, to Gorin versus City of St. Augustine, which was a change in elevation of a curb near the Leitner Museum. In every single case, it has been held over and over that some conditions are so open and obvious, so common and so ordinarily innocuous that they can be held as a matter of law to not constitute a hidden dangerous condition. And this step in our situation does not constitute a hidden dangerous condition. This isn't as to the duty to warn. This is as to the existence of a defect in the premises. There was no other testimony in the file. There was no expert witness. There was no testimony that there was a slippery substance in this area or a foreign substance. There is no evidence that Disney put a drain in this area. Even the dissent in Gorin recognizes, and it's at page, I don't have the page site, but the dissent states, "We agree with the principles established in these decisions that under most normal circumstances and conditions, ordinary sidewalk curbs, uneven floor levels, and uneven parking lot surfaces do not, as a matter of law, constitute latent, concealed, or inherently dangerous conditions." And they go on to state that that can be changed if the change in elevation involves a speed bump, which was the case in Bryan versus Lucky Stores, where immediately where the person would be stepping down was a speed bump. that is a situation where there would be a jury question as to whether or not that was a dangerous condition. Also, they cited to Hogan versus Chipka, where the surface underneath the change in elevation was a gully. And they said that would create a jury question as to whether that was a dangerous condition. And in the Jones case, Etheridge Jones, there's a situation, and that was really the first time this court has expanded the mode of operation to include something that was not a foreign substance, which is what all the Supreme Court cases have dealt with. But even there was a specific finding that the funneling effect went over a storm drain, and that created a potentially, and that was a jury question, is what the court ruled, as to whether that storm drain and that funneling effect created a dangerous condition. There's absolutely no evidence in this case. There was a storm drain, any kind of drain, that there was a speed bump, a gully, anything in this to change it from an ordinary change in elevation. And absent that, if there is no dangerous or unsafe condition, not just my client, but no landowner, possessor, can be held responsible for something if there's no problem that was created. The mode of operation argument and theory simply doesn't apply here because there is no
case a few years ago, and I can't remember the name of it. I thought it involved a Sam's Club or a Costco or something like that, where because they stacked the merchandise up so high, there wasn't anything inherently wrong with the way they had stacked it, but customer reaches up to try to get something from the stock up there and everything tumbles down on his head. Didn't some court here in Florida say that there wasn't anything inherently negligent about the way they stacked the boxes? They were stacked okay, but it was reasonably foreseeable that customers would reach up into the stock and that was a negligent mode of operation.
And I'll be honest, Your Honor, I'm not specifically familiar with that.
Well, I can't remember it either.
And it wasn't cited by either side.
I'd be making it up.
No, I'm sure you're not.
I'm still wondering, do you guys really call these holding pens?
No.
I know I feel like
It's
I'm
simply
in
a cue
one
line.
at times.
It's not a holding pen, not a bull pen. It's a cue line. But in the scenario we're talking about, I can see an argument anyway that a dangerous situation, a mode of operation created a potential for an unsafe condition, that being the box ready to tip or something under your scenario. But I don't see that.
I'm just trying to wonder here if, and I realize it's a fine line. On the one hand, I think we all acknowledge that it would almost be impossible for an entity like Disney to say, disabled people don't come here. I mean, you probably can't legally do that. On the other hand, it seems to me that if you advertise that, we're wheelchair friendly and just, you can access these rides, if you allow someone who has and apparently the young man that the woman was carrying here was, had a significant disability and had to be, carried on. Absolutely. If you're going to allow or encourage, and at the very least, I think we can agree that you allowed it. I don't know whether you encouraged it.
Not on every ride, but on the certain rides. Right. And this ride is one that is not handicap disabled accessible. However, if they're able to transfer, they can ride the ride.
I guess when I think about mode of operation, if you're operating rides or anything else but a ride, and you allow, if not encourage, but allow someone who has such a significant handicap as to where I think we would all agree that this young man could not have gotten on the ride by himself and he required assistance, which essentially meant, loading him up, in a fireman's carry or some other, I don't know how she carried him, but, significant physical exertion.
Precisely the way she carried him.
Does Disney then, is that mode of operation such that you then have to, provide some level of assistance if you're going to allow or encourage folks with that level of disability on the ride that you then undertake some greater duty to help them on and off. Again, it may be short of physically grabbing them and launching them up and down, but is it reasonable to assume that if you're going to allow people with significant disabilities to get on the ride, that you then undertake to give them some higher level of protection than you might someone without that disability?
It's kind of a long question, but I'll try to get to the crux of it. I don't think under our circumstances, and that's the way I understand the argument, they're not arguing that we should have somehow gone over and gotten a fireman's carry on this child and lifted it on. That's not our policy, and for many reasons. I can envision lots of scenarios where you could hurt someone. Number one, you can offend disabled guests by attempting to do things such as that.
And it'll happen. We all know you'll drop somebody, you'll knock them. Things will happen.
And you'll have workers' comp claims. You'll have allegations that the person was improperly touched. You'll have people offended that you touched their child. This lady, very courageous lady. She had come into the park. She was very familiar with the park. She went to town hall, undisputed testimony. She got the pass that enabled her to go to the front of each line. She knew from reading the brochure that this child had to be transferred. She did that. She had her husband there. She had a 17-year-old son who there's a photograph of that's as tall as I am that could have helped, but she's used to carrying the child.
When you get a handicap sticker or pass, whatever it is, they get a brochure that says, we're not going to go on and off.
She says she got a brochure, and what the brochure says is they have to be able to be transferred out of the wheelchair to get on certain rides. Certain rides are totally accessible. The wheelchair can absolutely go on many rides. And the more rides that come around, more now they are making more and more accessible. This happens to be a ride that has been there since, I think, probably since the park began. The Teacups is one of the original rides. It's been there for years and years, and it simply is not wheelchair accessible. She understood that. She'd been there before. She even said, and she wasn't certain, but she thought she'd been there before with this young man. She didn't have a problem. They have a photograph that's in the record that shows her lifting the child up and approaching the teacup that she was in, and there's no cast member shown. She said it was a female cast member. We don't know who that was, but there's no cast member shown in her photograph. She was picking the child up. She went over, and according to her, she was told, step up. So she was given a warning, according to her, when she got on. Now, some minute and a half, 2 minutes later, the only thing I heard as an argument of what we should have done to assist would have been to say, step down. Well, this is an open and obvious condition. There is no duty to say step down. There's no duty to warn. And even beyond that, there is no evidence in this case that we failed to maintain the property properly. There's no evidence that step was worn or that it was a jagged edge. These are some of the exceptions. There's no evidence that there was a hole beneath the step. There's no evidence we funneled her over a storm grate. There's simply no evidence at all that we did anything that created an unsafe or a dangerous condition. And absent that, to go back and try to pick apart our procedures is simply unfair. If you're going to require us to stand there every time a person gets on or off the ride and say step up, step down, number one, that's not a duty that's created under Florida law. And number two, you'd have to have a cast member for every single car and on every single ride, despite the fact that it's an open and obvious condition. This is a ride that's designed, and when she's assisted to get on, it's simply, they're allowed to board first. She says she was told to step up. It's not a situation where it's real difficult. When the ride ends, the doors open, you simply step up and walk off. You have a good view of what's around you because the cup's higher. She acknowledged that. She acknowledged that her one son had gotten off immediately. Her other child, her daughter, stayed with her until she attempted to exit. The daughter got off immediately before her, so she got to see the daughter exit. The photograph clearly shows that from her viewpoint of sitting, you can see not only the change in elevation on your saucer, your teacup ride, you can see it on all the other rides, or nearly every other ride. So it is an open and obvious situation. By law, under Florida law, it is not a dangerous condition. And if you don't have a dangerous condition, if we don't have a dangerous condition, you don't even get to mode of operation. There simply is no duty to warn, even though she was warned. There's certainly not a duty to warn a second time. And there is no unsafe condition or dangerous condition that we either created, knew about, or enabled, which would be through the mode of operation. If we had allowed people to take food and so forth, and somebody dropped a piece of food, and then somebody comes and slips on the piece of food, that arguably could be a dangerous condition created by our mode of operation. And that's been addressed by the Supreme Court in the Helen Holmes case. That's not the situation we have here. So, if you have any more questions, I'll be glad to answer them. Otherwise, I'm through. And I thank you very much for your time.
Thank you, Counsel.
May it please the court, the important, first of all, let me point out some facts. The ride operator does have a goal on how long the loading and unloading procedure and process was supposed to take, and the number of guests who are supposed to ride that ride per hour, and that's found in the record at page 192 and 193. But this court in Etheridge said that the owners...
So what was it? What was the turnaround time?
They didn't actually have a turnaround. He has a goal for numbers of riders and the amount. It's the numbers of riders per hour that he's supposed to foresee, and that turnaround time is occasionally timed by supervisors. But this particular deposition, the supervisor didn't testify to what the minutes were. The ride itself lasts for 90 seconds. I know that from my recollection of the facts in this case. But in the Etheridge case against Walt Disney World, this court found specifically that the owner's duty to maintain its property in a reasonably safe condition is not limited to detecting and warning patrons about obvious and dangerous conditions. The duty to exercise reasonable care may extend to taking actions to reduce, minimize, or eliminate foreseeable risks before they manifest themselves as particular dangerous conditions on the premises. In this case, it's reasonably foreseeable to believe that Walt Disney World knew that by having half of a policy in place that allowed the patrons to lift their handicapped children or family members into this teacup ride, that by not giving them assistance off of that ride, that could be a reasonably foreseeable dangerous condition when they're coming off of the ride, that they could trip and fall while carrying their loved ones. The testimony in this case by the supervisor said that the question was asked, if they offered and gave assistance in sitting onto the ride, would it be reasonable for a guest to believe that they would receive assistance in getting off the ride absent any instructions to the contrary? And the testimony was that it would not be completely unreasonable. That's as much as I could get her to concede in her deposition, and that's found in the record at 199-201. We believe in this particular case that we don't know if we'll prevail ultimately before a jury on this question, but we think that summary judgment was inappropriate based on the Etheridge case and the other cases that we've cited in our brief, that we think that Mrs. Berry should have an opportunity to present her case to a jury with regard to this, that we think that the half of the policy that Disney had in place created a reasonably foreseeable dangerous condition in allowing those family members to have to disembark without assistance. We thank you. We encourage this court to enter an order reversing the trial court's granting of the summary judgment and remanding us for further proceedings in that trial court.
Thank you, Counsel.
Thank you.
Thank you both. Court will